Hi, everyone. Harry here to talk about a significant loss in the full DC circuit for the administration, teeing up probably imminently a showdown in the Supreme Court. Okay, this is on this whole series of cases dealing with the president's power to remove people in the executive branch, and therefore dealing with the whole apparatus of so-called independent agencies that have exercised enormous power and implemented very important policy in this country since the New Deal. Recall the basic constitutional issue. The president can't just fire someone willy-nilly when they come in. There needs to be some kind of cause. That is the restriction that Congress has placed in the cases of certain agencies, and it's always stuck in the craw of unitary executive types who want to say, there's no such thing as an executive branch agency that the president can't just fire when they want to. That goes with the whole notion of executive power. But the Supreme Court to date has disagreed. A really important decision in 1935 said, you can do this, Congress, for certain kinds of agencies, and the agency there, the NLRB, had a multi-member board, and that board didn't exercise so much independent, especially prosecutorial authority, and the Supreme Court okayed it. And that stayed the law for a long time and was the model that Congress imposed in other agencies. For instance, most recently, the case of the Consumer Protection Financial Bureau, a single leader exercising a fair bit of authority, but Congress provided for that leader to be removed only for cause. And why do they do that, by the way? Two reasons. In order to insulate from politics. They're supposed to be somewhat impartial. We've seen what happens when they're not, because Trump has come in, ignored the law, and just fired them and basically put us back to scratch. And also because, in Congress's estimation, these agencies especially require specific expertise, and the president shouldn't be able to just mow down that expertise without some real reason, some cause. That's the whole issue here. Can Congress just require a for-cause requirement to fire? Okay. With the growth of the uber-conservative Supreme Court and the courts of appeals being sprinkled with Trump appointees, and with Trump coming in and firing people left and right, notwithstanding the law, it's been clear that the issue of whether that 1935 case is still viable, Humphrey's executor, would be reaching the Supreme Court. That has all been very much accelerated as of today. So last week, a panel of the DC Circuit, two conservative judges, Henderson and Walker, held that even if Humphrey's executor was good law, the district court shouldn't have ordered the United States to just reinstate the person that Trump had fired from the board. He's done this with both the NLRB and the Merit Systems Protection Board, with the upshot, by the way, that the boards just can't act, lacking a quorum. So that was the state of play, and now the entire DC Circuit, that is the whole court, each judge got together, made a vote, and the majority voted to nullify that opinion from the panel last week and say no, and say their basic point, and it really reads like a chastisement of the judges who had ruled otherwise. The one Trump judge, one Republican judge is, guys, the law is the law. Humphrey's executor remains good law. The Supreme Court has reaffirmed it repeatedly. We're a lower court. You just can't go out on a limb and start talking about constitutional principles that contradict binding Supreme Court precedent, which is exactly, by the way, what the Trump appointee to the D.C. Circuit said. Well, the Constitution provides thus and so, notwithstanding the screaming fact that the Supreme Court has ruled otherwise. So the whole court vacates that, and now we're back to where the district court was, meaning constitutional violation and because it's a whole separate part of the dispute, the order stands to say to Trump, reinstate those people and reinstate them now. That's going to be the element that really sends the administration into a tizzy. And you can anticipate an emergency appeal to the Supreme Court basically saying, we're going to win on the merits anyway. You guys, we know you're going to reverse Humphrey's executor. Why exactly? Well, just because that's how we read the vibrations of a couple opinions in the last few years, trimming things back. But it's a real emergency, and stop the music right now, because we've now been ordered to reinstate the two employees, and that's just going too far. That's overly strong remedial medicine to impose on the executive. Okay, back to the D.C. Circuit. The court as a whole held, as I said, that the case, Humphrey's executor, is still good law, and then just basically revived the reinstatement. There are several dissenting opinions by the predictable subjects, and especially a long one by Judge Naomi Rao, a Trump appointee who I think I can say objectively, and many people would, that is focused on a promotion, and it writes a lot of long opinions to try to play to the certain conservative crowd. But her big thing here now is both. The government's gonna win because Humphrey's executor isn't good law. Oh, how can you say something like that? It is good law until the Supreme Court says otherwise. But then she goes into this whole thing about how it's unconstitutional to require the president as a remedy to reinstate those folks. That just too much weeds in his garden and messes with the running of the government. That's going to be the immediate issue, teed up by the United States and requesting a stay from the Supreme Court. You gotta think that there's pretty good prospect, bad prospect, whatever, pretty strong prospect that the court's going to grant that stay. And at that point, they'll have changed the status quo once again, but also they'll have in front of them the case and the merits. Is this still good law? Are we going to go all the way now and overrule Humphrey's executor? And while they could just grant the stay and leave things to work out, now that the case is up there, it's likely that this becomes the vehicle for this pretty momentous constitutional issue, which portends a real change in administrative law, but really the lives, the daily lives of Americans that are so affected by these independent agencies. And that's now going to be teed up for a decision, possibly so quickly as by the end of this term, but in any event, in now the normal course of Supreme Court consideration. Quick emergency, I would predict, to freeze things on the remedy, but then this case and the issue comes in front of them, and it's a really important one. Talk to you later.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.